Welcome everyone to lecture number 28.9. So till now we have discussed till article number 19. Now we are proceeding to article number 20. What exactly this article 20 tells us? What is the overall view of it? The article 20 guarantees certain protection in respect of conviction for offences. Okay, so it prohibits retrospective criminal legislation, commonly known as post facto legislation, double jeopardy or punishment for the same offense more than once, and compulsion or give self-incriminating evidence. So what exactly is that? We'll discuss it in detail. Okay, so this article 20, it provides protection in respect of conviction for offenses. Okay, so it protects us, like it gives us right whenever like any criminal activity or any case is being happened on the person. So there are certain rights and there are certain laws that has been written under the constitution for that also. Okay, what exactly those things are, we'll see. Certain protections are given by the law. So no person shall be convicted of any offense except for violation of the law in force at the time of commission of the act charged as offense. Okay, so it doesn't mean like at the time when the law is committed. After that, if the law is passed, the person will not be charged for the law which has been declared as criminal activity before after the person has done a criminal activity. Okay, so these are the cases that we are going to discuss. Okay, the first thing is that no person shall be convicted of any offense except for violation of the law in force. No person shall be convicted of offense except for the violation of the law, that if he has violated any law, violation of the law in force at the time of commission, when he or she, the person, has violated at the law, and that law is running at the time of offense, like that law actually exists at the time of offense. Okay, then only the person will be convicted. Except other that, the person will not be convicted for that. So in the force at the time of commission of the acts charged as offense. Okay, so let us suppose X person can be charged for illegal act if and only that act is coming under the crime on that day of action. Later on, if the act becomes a crime, she shall not be charged for the previous action. Let us suppose, I will give you one example. There was earlier Damani case, that Delhi rape case happened. So when that thing happened, so if a person less than 18 years is there and he has done any crime, will not be charged as per the person who is 18 or plus years from that. Okay, there is the person, like there were many person, like around 3 4 5 person as far I remember, were involved in that heinous crime. Okay, in that one was juvenile, that one was less than 18 years of age. Now in that case what happened, so that person was convicted as per the Juvenile Justice Act. Okay, and there was no such act, there was no such law for which the person will be given the capital punishment, that is hanged till death. So only that person was saved. Rest of the person who was 18 years of age or greater than 18 years of age was considered under the criminal activity and was given the capital punishment. Okay, so now let us suppose when this case happened, after that the law was changed, and if a person is less than 18 years also and he is involved in a heinous crime. What exactly this heinous crime means, like that not a completely forgettable, forgettable type of crime, it's completely heinous, that like once in a thousand or a lakh that such type of incident happen. Okay, so even if that person is less than 18 years of age and he is involved in the heinous crime, then strict law as per the person who is 18 years or above, that law can be applied on that person. Okay, so now when this law came, and this Damni Delhi Act case happened, at that time this law was not there. This law came after this incident only. So the person who did that heinous crime will not be charged charged as per the act, as per the law which has been formed after that incident. Understood? Let us suppose I will tell you one more incident. I have slapped a minister. Okay, for slapping a minister, let's suppose there is no charge currently, that the person will be given 10 years of imprisonment. Okay, no such case is there, no such law is there. I slapped the minister on what date? On, let us suppose, in the year 2021. Okay, now after 6 months, let's suppose this act happened on June 2021. After 6 months, the law came. The law formed that if any person has slapped any minister, then the person can be convicted under the 10 years of imprisonment. Okay, so let's suppose this law came into force on 2021. Now this act has been done in June 2021, but the law has been implemented on December 2021. So that person who has committed this crime will not be charged as per the law. If the crime is being done, the law should be present at the time when the crime is being done, then only in that case the person will be charged on that case. Understood? Okay, I have talked much about this, I guess now you have understood. Okay, so nor be subjected to a penalty greater than which might have been inflicted under the law in force at the time of the commission of the offence. Okay, so neither that person can be extended for the punishment of previous crime by presently changed jurisdiction also. Okay, so this cannot also happen. Let's suppose a person is let's suppose a person has done a crime A. On the crime A, he was, as per the current law, he was given 2 years of imprisonment. Okay, and when he was going through this punishment, after 1 year, again the law has been updated, and it has been told that now this person, now if a person did the same crime, so the person will be sent for 3 years of imprisonment. Okay, 3 years of imprisonment. So the person who was already got a judgment by the court of the 2 years imprisonment can't be, his punishment cannot be extended at any case to the 3 years. He has been awarded at the time of commencement of the crime, he has been awarded with 2 years of imprisonment, so he will get 2 years of imprisonment only. Okay, so in Nirbhaya case, I have told you that Juvenile Justice Case and Protection Children Act changed, where person less than 18 years can be treated as an adult if he or she has done a heinous crime. Okay, after the Nirbhaya case happened, then only this verdict came that even if a person is less than 18 years of age, and if he or she has done a heinous crime, then in that case that 18 years of age person will be treated as an adult. Okay, so this verdict came after the Nirbhaya case. So who were the person convicted under the Nirbhaya case, who was less than 18 years of age, will not be charged as per this law. Okay, so but it was an applicable to this case because of this law was not applicable at the time of crime. Thus Nirbhaya, the person who was involved in the Nirbhaya case, who was less than 18 years of age, was not convicted as per this one. Okay, he was treated under the juvenile court. Okay, so yeah, so this was it. So now we'll see what exactly means by ex post facto laws. What does this mean? Ex post facto laws. Okay, see, similar to ex post facto laws of the US Constitution, we have India also have a ex post facto laws. Okay, what does this mean? It prohibits the legislature from enacting a criminal legislation with retrospective effects. Okay, we can't create a law which will have a retrospective, like in the past, if someone has done any crime, so we can't create a law which will be applicable to the like past days also. So if let us suppose if a crime A has been done on 3rd June 2022 and legislature has created a law with respect to the crime A only, where the law has been updated on, let's suppose, 3rd August 2022. So at no case this law will be applicable for those person who has been convicted under the law which was present at the 3rd June 2022. Okay, that is called retrospective. Okay, retrospective effect, that cannot be done, that cannot be go to the past days. Okay, so it prohibits this post facto laws. What it does, it prohibits the legislature from enacting a criminal legislature with a what? With a retrospective effect. It prohibits from such laws. Okay, so civil legislation can be enacted with a retrospective effect, but see, this whatever the laws that I am telling, it is respect to the criminal legislation. Okay, but civil legislation can be enacted with a retrospective effect. Okay, so let us suppose a case has been formed that earlier let's suppose 10 lakh rupees have been given for the purchase of a land A. Okay, now the government is telling, now the government has formed a law that this was let us suppose done on 3rd June 2022. Now government has framed a law that if you are making a purchase of land A in particular area, let's suppose area name area 1, location 1. Okay, so let's suppose now government is telling that if you are going to purchase a land in area 1, okay, so and the amount, if it is going beyond 10 lakh, then you will be getting discount of 20%. Okay, and this law came on 6th September 2022. So now government can also tell that this law is applicable for whoever person who has purchased earlier also, before year 20, after year 2010. Okay, so now this law is applicable for those also. So the person who has purchased the land on 3rd June 2022 will also get 20% discount. So the government will be returning 20% money to the such person. So this case will come under the civil law. Okay, this is not a criminal related law, and yes, this law is affecting past issues. So this is producing a retrospective effects. And it is allowed in the civil case. Understood? So in the civil legislation, it is allowed for a retrospective effect, and this is not compulsory. See, I am giving you that from past tense also this will be applicable. So it is completely up to the government only that they will provide or not. If they want to provide, they can do so. Nobody is restricting to them. If they want, they can also not do so. Like retrospective effect should not be there in this law. That is fine. But if they want, they can do so. But in the case if they have enacted in criminal law, even if they want, they cannot do so, because it is not allowed as per the constitution, because we follow ex post facto laws. Okay, now what exactly is present in the article 20 clause 2? No person shall be prosecuted what is this, man? Shall be prosecuted and punished for the same offence more than once. Okay, and this is applicable to judiciary only. So what does this mean? Let us suppose you have done a crime A. With respect to crime A, it won't be that you can be punished twice for the same crime. It can be only one punishment that will be applicable to a crime. Okay, so based on the maxim nemo debet bis vexari, like it means like based on, what does this mean? I will tell you. Meaning that a man shall not, one second, a man shall not be brought into danger for one and the same offence more than once, and it has been brought by the maxim perspective. So this is something called as a double jeopardy. Arey yaar, it is hanged. It is called as a let me pause this. Yeah, this is called as a double jeopardy. Okay, the man cannot be punished twice for the same offence. That is called a double jeopardy. So an IAS officer let us suppose sentenced to 5 years jail by judiciary. Now for the same offence you are dismissed from job also, not judiciary. That can be done, that is allowed. Let us suppose you have done a crime A as a IS officer. So what it has done, judiciary has given you verdict 5 years of jail, 5 years of jail. Now this, whatever the judgment this was given, this was by judiciary. See, very important, focus it here. Now what your office has done, office has expelled you. Now office has dismissed you from job. Now here what is happening, you are getting twice punishment, 2 punishment you are getting for the same offense. And yes, it is allowed. How it is allowed? If you see this article 20 clause 2, it is mentioned that no person shall be persecuted and punished for the same offence for more than once, and it is applicable to judiciary only. Judiciary can only give one punishment. Okay, judiciary can't give that after 5 years, within the 5 years you will get one more punishment. Okay, that cannot be done for the same act. But yes, for the same act you can be punished twice. Let us suppose one will be by the government, like you are being dismissed from your job, and one is by the judiciary. But at a time judiciary can give you one single punishment for a single crime only. Okay, no person. Now what exactly is article 20 clause 3? Article 20 clause 3, what it tells? No person accused of any offence shall be compelled to be a witness against himself. So it is by the law, if it is, let us suppose a case is running on you, you can't become a witness of your own case. Understood? And this is applicable to executive only. And this is applicable to executive only, not to judiciary. Okay, on the judiciary you can become a witness, you can become a self-witness, but on the place of police investigation and all, you cannot become a witness on himself or herself. Okay, so similar to US Constitution, 5th Amendment provides that no person shall be compelled to any case to be a witness against himself. So if a person confess a crime, judiciary will take as a witness, because let us suppose so judiciary will take is as a witness, because as per 20 clause 3 is applicable to executive and not judiciary, and valid only given at a judicial magistrate. Okay, so let us suppose if you have done a crime A and you accepted in front of a judge that you have done a crime, then you will be becoming a witness for it. Okay, but if in front of a police, if you are accepting a crime that you have, but in front of a police, if you are accepting that you have done a crime, this will not be applicable. Police has to search it, police has to dig into deep and come with a evidence for it. This is not applicable to executive, but yes, in front of the judiciary it can be do so, and this verdict has to be given in front of the judicial magistrate. Okay, so a confession statement given before a judicial magistrate is not valid, because there may be a confession or force or pressure. What do you understand? Like, let us suppose if you have given a confession statement before going to the judicial magistrate, like let us suppose it happened in the movie, we have seen that a confession has been written by the police and they took a sign of the person as well. Okay, at any case this confession is not valid. This confession can be done forcefully, right? Police can do so forcefully by using third degree. Okay, so at any case this confession is not valid in front of the judiciary. Why? This confession has to be accepted in front of the judicial magistrate, then only this will become a witness. Understood? So if any confession has been done in front of the police, the same confession has to be told by the person himself in front of the judicial magistrate. Only this confession will become valid, otherwise this confession will not be valid. It means you cannot become a witness of yourself in front of the executive. Police are executive, ruling government comes under the executive. Okay, so these things are not valid in front of the executive, but yes, in front of the judiciary it is valid. So Selvi versus State of Karnataka 2010 case, Supreme Court said that narco analysis and polygraph, let me give you example, light. Yeah, so in the Selvi versus State of Karnataka in 2010, what this case happened? In this case, it was Supreme Court said that narco analysis and polygraphic types of tests are unconstitutional. Are unconstitutional because it violates what? It violates right to privacy. It violates right to privacy. So as per Article 21. Okay, yeah, so it violates the right to privacy. So these states force the accused, and it states that this test force the accused and it is state of mind. Now what happens in this type of test? It is we are forcing, what we are doing, we are actually forcing the person and his state of mind. Okay, so this test is unconstitutional as per the Supreme Court, but fingerprint will not become unconstitutional because the result will always be the same even if your state of mind is different. Okay, so Supreme Court said that these tests are not reliable. Okay, and you are violating the Article 21 that is given to a person in the fundamental right to privacy. Okay, you are violating this thing, and this test, within this test you are forcing a person and a state of mind. Okay, that's why as per the Article 3 we are telling that Article 3, if a person is accused, he cannot compel himself as a witness in front of executive. Why it happens? Because police, we have seen that police have used third degree to accept to get a confession from any person. Okay, and that is not allowed as per the Constitution. The confession must be done in front of the judiciary only. So what in this case also it is doing, what we are doing when we are doing a narco test and polygraphic test, actually we are doing the same thing, that we are forcing the individual's state of mind to take out some information from them. And even we can't tell 100% whatever the information we have received is 100% correct only. There is a chance of error only. No machine is 100% proof. Okay, so that's why these things are unconstitutional. And but yes, the fingerprint case, if you are taking a fingerprint and all, so yes, these things are not unconstitutional because even the person's state of mind is not correct, the fingerprint will be the same. Even the person is in the normal circumstance also, the fingerprint of the person will be same. And when he is not in conscious, when the person is in unconscious state, in that case also the fingerprint will always come the same. However, it does not bar the voluntary administered test. Okay, if the person is coming voluntarily that okay, you can do a test for me, in that case uh, uh, it is not stopping the executive to do so. But at any case, this cannot be a proof in front of the court. Executive have to come with some evidence to show, to prove their consent. Okay, at any case, this polygraph test will not be considered as a proof in front of the court. Okay, so this does not bar the voluntary administered test. Then only on the permission of the judiciary you will go under test. If the judiciary is given a permission that yes, go and take a narco test of a person or polygraphic test, yes, you can do so, but you have to take a special permission from the court. Okay, but this thing will never be acted as a evidence. You can use, the executive can use this thing in their case to find evidence for it. But at any case, this polygraphic test or narco test, which has been approved by the Supreme Court also, at any case it cannot be acted as the evidence, and it will be a statement to the police. It will only be a statement to a police, not a evidence, and this statement will be examined and verified. Okay, this has to be examined by the police, it has to be verified by the police. In that case only this will be applicable. Okay, so this was all about in this article 20. We'll proceed for the article 21 in the next lecture. Thank you. Please like and subscribe. This is a new channel, we really need your support. Okay, thank you.